Title Talk with Lora Rosenthal. Today's episode is regarding deeds and titles. Any information given on this podcast is not legal advice, and we are not liable for any action taken based upon the information. Deeds and title are two synonym words that are commonly used in conjunction with each other. Commonly known as a title for a car, people sort of refer to deeds to your home as title. So today I'm going to refer to the document as a deed. A deed is your legal ownership to a piece of real property. Now, title can be held in the name of an individual, individuals by tenants by the entirety, tenants in common. Those are generally the common way people take title on their deeds. Now, what does this really mean? When one person is listed as the owner of the property in the grantee section of the deed, that person owns it individually. That means that individual owns 100% of the property. Tenants by the entirety, or tenants or by husband and wife, mean that they own the property 100% together. Tenants in common, or when two people not married own the property, and each person can have a certain percentage of interest. Commonly 50%, 50%, or it could be multiple individuals each holding a different percentage. But regardless of the number of people found in the grantee section of the deed, the percentages must equal 100. So what are some common deed issues? Well, if you are a woman and then you get married, your name changes. So you may be on the deed to your home as in your maiden name. So then you go to try to put a mortgage on the property, and now the title company is asking who this person is. So then you would have to do a new deed from you under your maiden name to you underneath your married name, or even adding your husband onto title to the property. That's a common deed issue we see. Another common deed issue is misspellings of your name. Like, for instance, my name is spelled Lora, Lora. Not a very common spelling. Most people spell my name Laura. And once that deed is recorded with a misspelling, and then you go to sell the property or you mortgage the property, the title company is going to point out this spelling error. How do you fix it, you say? Well, we can prepare a new deed running from your misspelled name, such as Laura, also known as AKA Lora Rosenthal. That's a common way of doing it. Or when you are having you took title in your maiden name, you do Lora Schultz, now known as Lora Rosenthal. So to show that that person had a maiden name is now a married name. Commonly we see in title as well when a trust owns ownership of the property. And you will see trustees' names. So you would see John Doe, as trustee of the Mary Doe Trust, or you can see multiple trustees as owners of the property. You have to look at the trust as if it was a entity, a separate standalone company. So in theory, the trustees are empowered underneath the trust to transfer the property. Also, there's revocable trusts where the grantor of that trust can transfer the property during their lifetime. Also, we see deeds in corporations' names, LLC, which is limited liability, and in corporations. So, however, they're very different than the trust entitlement on the deed. When you have a corporation, you would just have XYZ Corporation. In title, we need the corporate documents to ascertain who is legally can transfer that property. An LLC is considered a limited liability corporation, and we, as title, would request a copy of the operating agreement to see how many shareholders, known as members, there are to that corporation. Based upon the number of members, those members are the authorized signers on behalf of the LLC who should be signing the deed. Also, with any other type of incorporation, we would need to see those corporate documents. So you're telling me what happens upon death and when we have all these deeds entitled differently? Very common in title, we'll get a phone call from someone that says, my mother left me the property. I inherited, it's my property. Well, the first thing we have to ask is that, is there a will? Is there not a will? If there is a will, you would need to take that will to probate, which is a surrogate court proceeding, hire an attorney, and that probate court would appoint you as the executor of the estate, and you would get permission underneath a piece of paper called a letters of testamentary. We'll go into that at another podcast. Also, if there is no will, that means that person died intestate, meaning there is no will that can be found or no will that could be probated in surrogate court. So then you would have to commence an administration proceeding in surrogate court to be appointed as the administrator in order to transfer that property. So then we would see in the grantor section of the deed, John Doe, as executor of the estate of Mary Doe, or John Doe as the administrator of the estate of Mary Doe. But also, now we're talking about what if it was tenants by the entirety, you ask? Well, that's husband and wife. If the husband dies before the wife is the sole owner of the property by operation of law. You would need to provide to the title company a copy of the death certificate. Now, what do you ask about tenants in common? Well, tenants in common mean, as we went over before, each person has an undivided interest in the property. So now John Doe and Jane Doe each own, for our intents and purposes, 50% of the property. 50% for John, 50% for Joan. Well, guess what? Jane Doe dies. Her 50% is now, who's entitled to her 50%? John Doe is not entitled to her 50%. Her 50% now goes to 25% would go to her husband if she was married, and the remaining 25% divided among her children. If there were no children of the marriage and she was not married, then once again, it would have to be probated for that 50%. So it's sometimes you see tenants in common with rights of survivorship. What does rights of survivorship really mean? Well, Lora Doe and Jane Doe own property together. We're tenants in common with rights of survivorship. That means if Mary Doe dies, Lora Rosenthal takes the property 100%. So that way it avoids probate and passes to the remaining tenant in common free and clear. So it's very important when you have purchased your property or you have added someone onto title for the purposes of credit, or someone is not alive anymore, to redo that deed to make it nice and clean and clear who is the actual owner of the property. So if you need any more additional information, you can reach out to us on our website. This is a very complicated situation, and it's very important that we read the deeds to see what it really is. So at this particular point, we're going to, our podcast is now closed, and our podcast can be found on our website or your streaming platform of choice. Thank you.